The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
And totally denying that he's in line to be Donald Trump's next Supreme Court Justice, Stuart Address.
Oh, thank you very much. Thank you. That's the first time I've ever heard my name associated with Supreme Court Justice in the same sentence. If he is stupid enough to pick me, I will happily serve my country. And I'll be the 5-4 vote on the other side.
I love it.
Anyway, good morning, Treasure Coast. I'm doing a little bit of technical stuff right here since Facebook does not want to cooperate. And I'm going to say hello to all of you. And I hope that you're having...
Something's making noise.
I hope you're having a good Friday. Anyway, this is your opportunity to give me a call. Ask me whatever questions you might like. I will do my best to try to answer them. And we will see if I can help you. If I can, I'm happy to do so. And if I can't, I'll be honest with you and tell you it's just not my area, and I'll do the best I can to maybe steer you in the right direction. So we are going to continue today with defamation. We had ended the defamation discussion sort of talking about qualified immunity.
You're wrestling with it.
Yeah, I'm wrestling with this, and if you're not watching live, you probably don't know what's going on, but we have a little bit. We're trying to do some Facebook streaming, and for the first time it decided to freeze up. So the only way I can deal with that is to shut down the iPad, let it start up again, and hopefully the people who are there will still be there when I come back. But
that could have been the building, because something happened at the very end of your commercial. And the ID didn't roll, and it got jammed up. So
it's your fault.
It's probably the guys.
Who do I sue?
The guys on the street. Sue them.
Oh, that's right. They're down the road doing some work.
We were worried about that.
I guess I'll sue the city.
We've been worried about that. That's Florida Power and Light is doing a wonderful job.
Anyway, we ended up talking a little bit about qualified immunity. And essentially, we'll sort of start there. Then we'll move into a little story, which I hope you'll find interesting. And we'll continue on with defamation. And in the middle, ask me any questions you want. So, qualified immunity is where an individual makes a statement that would otherwise be defamatory, false statement of fact, that carries with it some privilege. In other words, if you reasonably believe that somebody has committed a crime and you yell it from the rooftops, that's defamation. On the other hand, if you reasonably believe that somebody has committed a crime and you contact the police, that is not defamation. There you have a qualified privilege. And the only way you can lose that privilege is if the statement that you gave to the police was knowingly false, malicious, if you had some undermining motive to get back. And probably a better example of that would be you call DCF and you allege that your former spouse is abusing your child. Now, if you reasonably believe that to be true, even if it turns out not to be true, you have a qualified privilege and you have a qualified immunity, and you are not going to lose a defamation suit. But, on the other hand, if you know that the statement is false that you make to DCF, or you make it with a reckless or even a negligent disregard of the truth, you might lose your qualified immunity. And you might have to face a defamation suit, which ultimately you could lose. So there are a number of areas in which you can have this qualified immunity. DCF is a great example. It's a common one. The police is another great example. It's essentially, if you are making a report to any governmental agency, any law enforcement agency, any agency which has a duty to investigate, if you're calling OSHA on your employer and accusing it of violating regulations which would constitute a felony, you have a qualified immunity. So it's important to just determine that the immunity ends when you start engaging in conduct which you should know is wrongful. If you're being willfully false, if you don't care whether you're being true or false, you don't even know the information, then you're probably going to lose your immunity. So, what is the burden of proof in defamation cases? We start out with the standard defamation case, which is most of them, a private individual suing a private individual, and the burden of proof is simply a preponderance of the evidence. What does that mean? I've talked about that before in other contexts. What that essentially means is that you have to prove to the jury or the judge, whoever the finder of fact is, that you were right by 50% and a feather. So really it's a gut instinct. After hearing all the evidence, it's who is believed, and that is good enough. If you as the plaintiff are believed, you win your case, and then the issue becomes damages and how much you're going to get. If you are not believed by 50% and a feather, you're going to lose your case. Now, where it switches the burden of proof is in cases of public figures, for the most part. So you're accusing the New York Times of slandering you based upon this article they wrote where instead of using the word allegedly committed this crime, they said you committed this crime. Now, you're going to have to prove by clear and convincing evidence.
They better say allegedly. In journalism school, we got hit over the head a million times.
Journalism 101, right?
You betcha. Yep.
Well, the alleged president. No, okay. So you have to prove by clear and convincing evidence. What is clear and convincing evidence? It is somewhere between 50% and a feather, which is preponderance of the evidence, and the criminal burden, which is beyond a reasonable doubt, which lawyers like to describe various ways. I'm not a criminal defense attorney. So I would say that if I'm a juror in a criminal case, to me what that means is I'm like 98, 99% certain that the guy is guilty. There is no rational reason that I can see that he wouldn't be or she wouldn't be, and I'm not going to lose sleep over saying guilty and putting this person in jail for the rest of their lives, perhaps. So, clear and convincing evidence is somewhere in the middle. Where in the middle? Good question. Nobody really knows. Is it 70%? 75%? It's not like the jury gets a questionnaire. By what percentage do you believe? No, they are instructed that the plaintiff must prove the claim by clear and convincing evidence, and it is given a generally vague description, like I've sort of just given to you, that it's more than a preponderance of the evidence. It's less than beyond a reasonable doubt, and it's for you, the jury, to figure it out. So one set of facts, one jury might find one way, another jury might find another way. But very often in these public figure cases, you do have to prove by clear and convincing evidence.
Of course, there can be an artichoke on the jury, too, and that really messes things up.
Well, that is true. So before we then go on to damages, what kind of damages can you recover in a defamation suit? Or if you're being sued, what is your exposure? let me tell a what lawyers like to call a war story. I hope you'll find it's a funny one. I know that everybody in the courthouse did. About a case I had about, maybe 10 to 15 years ago. It's in Martin County. And there was a restaurant, which I won't name, no longer there, on US 1 in Stuart. And with respect to one of its employees, the owner made accusations that that employee was a thief, a scoundrel, an adulterer, and a whole number of other things that are just really off the wall.
That's all he said?
Probably a lot more. And those things we talked about are defamation per se. When you're accused of a crime or accused of something that has to do with wrongdoing in your business, defamation per se. So you don't even have to prove intent, and you don't even have to prove damages, although it's helpful because you'll get more damages. Those things are presumed, which is it's two of the four elements of defamation you've already have presumed. It's a great leg up. So we filed suit, and we got the most curious defense I have ever seen in 33 years of practicing law. We got the defense that the defendant had an immunity, but it wasn't a qualified immunity. It was diplomatic immunity, an absolute immunity from being sued. And with that, I think, do we have a call? So we're going to leave that as a cliffhanger. Right, Cliff?
That's right.
All right, we have, it's either Eddie or Edie, I'm not sure, on line one. How can I help you?
Yeah, Eddie. Hi.
Hi, Eddie. How are you?
Just got an off-the-wall question here for you.
Sure.
I was wondering, can a U.S. citizen be sued by an illegal alien?
Yes, a U.S. citizen can be sued by an undocumented immigrant.
Good question. Good question.
And it is a good question.
Yeah,
Here is the risk. Here's the risk for the undocumented immigrant. The undocumented immigrant does not have a privilege of not having the court call Immigration and Customs Enforcement to pick up their posterior and remove them to wherever they came from. And it is frankly one of the reasons that migrant workers, which we have a lot of in this area, are so afraid to come forward when they're not being paid minimum wage, when they're not being paid overtime, or when there's a whole bunch of other things that may go on. They're afraid to come forward because they know they might be able to win their case, but they might not win it from this country.
Yeah. All right. Well, that kind of answers it. Would you represent an illegal alien by any chance?
Well, it all depends upon the facts. I think I would if the undocumented immigrant has a legitimate case and understands the risk that there might be a report that leads to actions that it doesn't really want, he or she doesn't really want. Yes, I would. Just because they came here without going through the proper process does not mean that they don't have certain rights under our laws, but they also have to accept certain consequences.
Okay, well, thank you for your input, and I appreciate it, Joe.
You're very welcome. You too. Take care. It's a good question.
Wow. Yeah.
It's a really good question because, as I drive down Midway, and I see Tropicana and I see all these other places, you do have a lot of undocumented workers on the Treasure Coast.
Sure.
That do lots of menial labor, important labor, but, backbreaking labor. And I've had calls from some of them, and, most of them decide not to pursue it when I explain that they face certain risks. If somebody says, we know you're undocumented and we're going to call somebody, and it's unfortunate, but that is the law. So going back to the cliffhanger, the defense was that the restaurant owner had diplomatic immunity and could not be sued. Why did he have diplomatic immunity operating a restaurant on US 1? Well, because in addition to being a restaurateur, He was also the royal foreign minister of the United Kingdom of Atlantis.
Of Atlantis.
That was my reaction. And so they filed a motion to dismiss. And I had to prepare to deal with it. So I did a little research. I Googled the United Kingdom of Atlantis, and I found a beautiful webpage, a government webpage. It showed me who the king of the United Kingdom was, all the ministers, and the first ladies and first theses, and the economic import, and it was a beautiful, beautiful website. But I was still a little bit suspicious. I mean, the United Kingdom of Atlantis. And then I looked at, well, where was it located? It was just off the coast of Australia on a tiny island.
Oh, there you go. Okay.
And, that made me a little bit more suspicious.
Little island nation.
Yeah.
Sure.
In Nigeria.
Right. So I did a little bit more research, and I went to the United Nations website, and I found that the United Kingdom of Atlantis was not a recognized nation state
You think?
by the United Nations. So I got a certified document from the Secretary General of the UN indicating that they don't recognize any nation known as the United Kingdom of Atlantis.
They actually wrote you a letter.
Oh, I went through formal procedures, and I asked, can you certify whether this entity is a recognized nation state
That's
of the kingdom?
Cool.
And then I called the Department of State. Of course, I didn't speak to anybody fancy, but I said, look, I'm a lawyer, et cetera, et cetera. Guy claims to be the Royal Foreign Minister of the United Kingdom of Atlantis. I know that the United Nations doesn't recognize any such entity. Can you tell me, does the Department of State recognize the United Kingdom of Atlantis? And somebody got back to me and said, no, we don't recognize any entity known as the United Kingdom of Atlantis. I said, well, could I get that in writing, that on a government seal or something, so I could use it in court? And I got that too, under, theoretically, the seal of the Secretary of State, who I'm sure didn't even know he had signed it.
But they did send him $55 billion in foreign aid, though, right?
Yeah, probably. So I was armed with my UN seal and my Department of State seal. And I went in and, I prevailed at least on the motion to dismiss, so the case was going forward. And the judge was equally incredulous when the attorney for the other side, who I won't name and is well known, and I've dealt with him many times, and he is very creative in the things he argues, tried to assert this diplomatic immunity. It even got the attention of the sheriff's deputies, who stand around in the courtroom. And whenever I had motions, I heard later on that all the deputies jockeyed. They wanted to be in the courtroom to hear about the United Kingdom of Atlantis.
Yeah, it's not bad.
So we started what's called discovery, and there were some motions back and forth, so we'd have to run to hearings all the time. Finally, I asked, and I did this for a reason, I'll tell you the reason in a moment. I asked for the address and the contact information for the king. Theoretically, so that we can contact the king and verify this royal foreign minister's employment. And, there were all sorts of objections. The king's too busy. And so I had to file a motion to compel to get the address and telephone number and the information of the king. And in between that time, I discovered, by doing a little bit more searching, that the federal court in one of the districts, I don't remember which one, in Texas, had a warrant out for the king.
Come on.
He had been charged
This is absurd.
he had been charged with tax fraud and racketeering
You think?
and was a wanted fugitive from American justice. So I contacted the assistant U.S. attorney who was prosecuting that case and who would probably never find the king again. And I said, hey, guess what? I'm suing the royal foreign minister, and I just asked a discovery for the location of the king. And he was very interested. Gave me some appropriate official documents again that the king was a fugitive. And when I went in on that motion to compel, and there's all this yelling and screaming by the attorney on the other side, what difference does it make? Does he have the address and the contact information of the king? This is a fishing expedition. This is burdensome. This is harassing. All he wants to do is harass the king. I said, no, Judge. First of all, I want to verify BS. I want to verify this guy's employment. Okay, that's my legitimate reason. I said, and by the way, Judge, here is a document that shows that the king is a fugitive from U.S. justice and is wanted by the FBI. And he is accused of tax fraud and racketeering in the whatever district of Texas in the federal court. And I've been in contact with the assistant U.S. attorney handling that case, and they are very interested in the location of the king. I can tell you, I remember it as clear as day. The judge looked at me with wide eyes, with a smirk that he tried very hard to refrain
Not
from,
open laughter,
from
right?
showing. There were, motion hearings, there aren't a lot of people in the courtroom. But there were other attorneys in the back who had cases to be called after mine. And there was a bit of chuckling going on in the courtroom.
Yes.
And I don't know which deputy got the luck of the draw to be in the courtroom for that particular hearing, but I'm sure he had a great story to tell. And the judge turned to the defense attorney, and he said that motion granted. You have 10 days to tell him the contact information of the king, or we'll continue and we'll determine sanctions.
Wow.
Well, within 1 week, the case settled.
So how long was all this stuff? Was this over months?
This was probably about, from the time we filed suit, this probably was a good 6 months or so until we were able to get to the point where they had to disclose the king's whereabouts. And, of course, the royal foreign minister was never going to do that. So they decided to settle the case with the former employee.
Oh, man.
But that is a defamation. It was, there was a defamation case there, folks, and we had to deal with the Kingdom of Atlantis and the royal foreign minister and the king. And hey, if I had to go to that kingdom and take the deposition of the king, I was ready to travel. I just didn't know where to tell the airline to take me.
Air Atlantis.
I don't think we had any longitude or latitude coordinates. It was just some island off the southern coast of Australia. And there are a lot of them, tiny ones, that nobody can live on. But it was a scam, and if you then Googled, you'd find lots of posts about it being a scam. And if you look now, there is no mention of the United Kingdom of Atlantis website. At best, what you will find is a reference to, there once was, like in Wikipedia, and it was determined to be a fraud and a hoax, and places that people could hide their money, that kind of stuff. So.
Wow.
That happens in Stuart, Florida.
Oh, man. Well, I'm sort of amazed that the judge would let it go on that long.
Well, there are rules and procedures. There was no way for me to automatically just win. I got to go through the process of discovery and try to prove my case. He didn't stop the case based upon this claim of diplomatic immunity, which was good. If he had, then I would have had to appeal to the 4th District Court of Appeals. But he denied their motion to dismiss based upon immunity because it seemed so absurd and flimsy, and he let the case go on. But then you had to go through the process of discovery, until the bright idea came upon me, ask where the king is.
Sure. Yeah.
And then, of course, they objected, and then you had to schedule a hearing. Then you had to get to the hearing. It was probably postponed once or twice because the other side would try to avoid it. And then you had to get in front of the judge, get the order, tell them where the king is, and I sort of knew that would end it, and it did.
So how much did this cost the taxpayers?
Oh, it didn't cost the taxpayers anything. I mean, it cost my client. I had the case. Obviously, it's a defamation case. Most defamation cases are on a contingency fee.
Mm-hmm.
So it cost my client my percentage of whatever it is that he was able to recover.
Yeah. Wow.
And if I hadn't recovered anything, I would not have made any money, and I just would have had this lovely story. But fortunately, we did settle and got a little money out of it, too, and I honestly don't remember how much.
It's a classic story.
It is.
That should be in a textbook somewhere.
And I tell you, if you go to Martin County Courthouse, I'm sure there are people there, it's been a while, that will remember the case of the United Kingdom of Atlantis. Because there were deputies there that wanted to be in this courtroom more than they wanted to be in criminal courtrooms where there were interesting things going on.
Oh, my.
So, that's just the way things work sometimes.
Sure. Yeah.
So let's go to a more mundane topic. What are you going to win if you win your defamation case? What kinds of damages are recoverable? Essentially, you have a few different types of damages. One is called general damages. And general damages are essentially, compensatory damages. What kind of damage has actually been done to you and can be expected to be done to you in the future? So, for example, your employer fires you because somebody calls him and says, I have evidence that this guy is a thief or a rapist or whatever. And the employer decides, I just don't even want to get involved in this. I don't want to take no chances. I'm sorry, but you're fired. Well, you have hard economic damages now. You have loss of income up until trial, depending upon you may have gotten other employment. Maybe that other employment isn't paying as much. You have to mitigate your damages. And then you have, what about future damages? How long can it be expected until you can recover enough to get back to the level of income that you were previously making?
But when's a trial going to be? A year from now?
More like
2?
2.5.
Yeah.
Unfortunately, in our circuit, which is the 19th Judicial Circuit, we have, I think in each county, one circuit civil judge. When we're lucky, and I think in St. Lucie County we are lucky right now, we have one circuit civil judge for juries and one circuit civil judges for bench trials. For quite a many number of years, we had one circuit civil judge, period. And the reason is that there are constitutional requirements with other areas of law. Criminal law, if a defendant demands a speedy trial, he's entitled to a speedy trial or he has to be let go. Family court, there are issues of kids and their physical safety. Drug court, there are a number of other divisions of the courts where there are either constitutional requirements or other important issues that let you have, 5 judges in the criminal division, 4 judges in the family division, and 1 judge in circuit civil. And so circuit civil takes forever, really, to get to a trial.
Would you rather have a jury trial or a judge-only trial?
That depends completely on the case. If this is a case where I want to pull heartstrings and get judges either emotional or angry, or jurors angry, I need a jury. I'm not going to get away with that with a judge. I need, you're not allowed to quote-unquote appeal to the emotions of the jury. You can never say to a jury certain things outright. But there are a lot of ways to communicate and tell stories that anger people or emotionally get to their heart. And that is where damage numbers go way up. A judge, on the other hand, is great if there are more technical cases, more complicated cases, and you need somebody who is not going to be confused by the defense storytelling that is going to try to go up 5 different avenues that are irrelevant just to confuse a jury. So it really depends on every case, and I have that discussion with my clients. We have Gene on line 1. How are you, Gene?
Well, I'm not near as interesting as Atlantis, but I do have a question for
Sure,
you.
go ahead.
I bought a car for my son, and we bought it from a friend. It had plates on it, and she allowed us to keep the plates until we could get it registered, of course. And my son, in his infinite wisdom, took the vehicle out with a girlfriend of his.
Right.
And they proceeded to go somewhere and have too much to drink. He left with a friend. His girlfriend, who is actually a neighbor, took the vehicle and went to return home, but in the process got a DUI and in an accident.
Okay.
Destroyed the vehicle. I called my insurance company and her insurance company. Both are State Farm. State Farm, for her, said they would cover the vehicle.
Okay.
They wanted to total it. I said fine. I had paid $1,000. I paid $200 to get it out of impound, so I would take $1,200.
Okay.
In the meantime, State Farm comes back to me and says, in order to pay me for the vehicle, I have to go to the Department of Motor Vehicles, pay the tax, pay for plates, and transfer it to my name, because they will only deal with the titled owner, not the person in possession of the title.
And that makes sense.
And I said, well, make the check out to her, because if you look at the title, the address for her and my address are the same.
Okay.
She was living with us when we did the swap vehicles. My son swapped his Volkswagen for her Explorer. They still won't deal with me. I said, well, then I'll just have to take the daughter who was driving the vehicle to court, and then you'll have to pay for it under her liability. Am I correct or wrong?
Well, okay, let me try to ask a couple questions to make sure I understand, because I'm a little confused. The title was in actually whose name after the vehicle was purchased?
My son's ex-girlfriend.
Okay. And it hadn't yet been registered with DMV?
Correct. No, it was registered to her.
To her.
At my address.
So then why didn't she contact State Farm, her own insurance company, and deal with it on her own and get the money and reimburse you if you're the one who actually paid for the car?
Because she no longer had insurance on the vehicle, because she had had a DUI.
Okay.
And couldn't get it insured with the blow and all the rest of the stuff.
So the insurance was under whose policy?
There was no insurance on the vehicle at the time of the accident.
So why was State Farm involved?
State Farm is my insurance company, who I would have called to insure it when I transferred it.
But you didn't insure it, right?
No, I didn't get that far.
Okay. So I'm actually confused.
We were going to do that on Monday, and on Friday night they went out partying and wrecked the car.
All right, 2 things. I'm actually confused as to why State Farm would ever even offer to pay under those circumstances. And second, typically when you make the purchase, I mean, maybe I'm confused, but in my experience, the insurance company is contacted immediately because the vehicle is not really supposed to be sold unless it's covered by insurance.
Well, it can be sold, but in order for me to get plates on it, I've got typically 30 days with State Farm to buy the vehicle and then go to the Department of Motor Vehicles and get it transferred. I do need to call them and tell them this is my new purchase.
Right.
But the girl that was driving the vehicle when it was destroyed also is covered by State Farm under her policy.
But I thought you told me she didn't have any policy.
No. 2 different girls.
All right, then I'm confused. I'm sorry.
Okay. girl. Let me, instead of saying girl, let's say neighbor.
Okay.
Neighbor and my son went out. Neighbor was driving the vehicle when she got a DUI
Okay.
and destroyed it.
Okay. And she had a State
Girlfriend-
Farm policy.
And she has State Farm
Okay.
policy. But they don't want to deal with me because his girlfriend's name was on the title.
Well,
She's gone.
I have to tell you, that makes complete sense to me. To State Farm, you are a complete stranger to the issue. You have no legal standing. They have no obligation to you. The obligation is to the insured. The insured is neighbor.
Correct.
So if neighbor, essentially with your son's permission, was driving the vehicle, had an accident, DUI, she should be liable to him for the damages to the car, which was, she should be liable to girlfriend for the damages which were caused to the car, which was titled in girlfriend's name.
Correct.
So girlfriend should be making a claim on the insurance policy of neighbor. That's the way it would work.
Correct.
But
I can understand that.
right, but so I can understand why State Farm won't deal with you.
My only problem is I told State Farm, look, I'll be more than happy to go through all of the process to transfer the title to my name.
But it's too late. The vehicle accident occurred while girlfriend was the record owner. If she transfers the title to you now, that doesn't give you rights to go after neighbor for the damages neighbor caused when she had the accident.
Okay. So I still told him make the check out to girlfriend.
But
Girlfriend
the
will
problem is
endorse it over
you're
me
the one telling them that. Why isn't girlfriend talking to them?
because she's in Texas.
Is she okay? Is she no longer cooperative? Is what you're saying?
Oh no, she's cooperative. That's why I said make the check out to her.
All right, well,
I'll be more than happy.
Then she needs to be the one making the claim and communicating with State Farm. Or I've seen this happen, and I've even done it in my own
Power of
family.
attorney?
No. She needs to call, and you need to be on the line as well, and then she gives permission for them to talk to you. Sometimes, let's say, girlfriend may not be as competent to have these discussions, and so, she wants somebody that is more able to, talk about these types of things. But the way to do that isn't a power of attorney, really. I mean, it's a very expensive, convoluted way of doing it. It might work. The best way is for girlfriend to call, have you on the line, and say, I'm giving permission to Gene for him to explain what's going on my behalf so we can get this resolved.
Okay, I can try that.
I think that's the best way, and probably the only way, without spending a lot of money, that you're going to get this resolved, to your satisfaction.
Okay, even if I went and did all the title transfer and said it was as of the date prior to the accident?
Well, I mean, first of all, I don't know whether that is, as they say, kosher. And second of all, while she could transfer her rights to you effectively as of that date, even if the title isn't as of that date, that is a more complicated way of doing it. It really is.
Is that like post-dating a check?
I don't know. I mean, you can give somebody, you can buy, somebody could transfer their interest, their rights to you to a claim. But then, State Farm may make you jump through all sorts of hoops. I think the easier way is for State Farm to be dealing with her and having you speak with her permission. And again, she's not even the insured. The insured is neighbor.
Correct.
So girlfriend would be calling neighbor's insurance company and saying, I'd like Gene to explain this on my behalf. It's my claim, but, he can talk better to you. And I've seen that, and I've heard that done, in other situations.
Well, my biggest problem with the thing was it's going to cost me $300 to $400 to do all the transfer and insurance and taxes, and they're going to want to give me the same amount of money as they would without all of that.
You may be right, because I don't think they're going to give you the $1,000 you paid, and there's certainly I doubt they're going to compensate you for the the towing or the impound lot or whatever that is.
Well, I've agreed to take $1,200, and the vehicle has a blue book of $2,000.
All right, well then maybe you will get the $1,200. I know that insurance companies, they use 3 different sources. They average them out. Sometimes, I've had a couple cars that have been totaled, unfortunately. Sometimes you're happy with their valuation. Sometimes you're pretty irritated with it. Then I've known people who were ecstatic over the valuation. So, you never really know until they make the offer.
Well, my other option was to go to small claims court, but am I in the same boat there?
Yeah, you're not going to win. You have no standing. If I was the judge, I'd throw you out of court in a heartbeat. You have nothing to do with this matter legally.
Other than I'm in possession of the title.
Well, you may be in possession, but you're not the title owner.
Well,
And you're not the person who was the owner at the time of the accident.
Well, when you buy a vehicle and you go to the Department of Motor Vehicles to transfer the title, in that interim period, who's the owner?
When you buy the vehicle, the title is signed over to you on the back.
Correct.
And while the DMV doesn't have you registered at that moment as the legal owner, you become the equitable owner. And then once you file that title, you are now also the legal owner.
So as the equitable owner, do I have any rights?
You're not the equitable owner. When that vehicle was purchased, whoever was selling it presumably had the title and signed the title over.
Correct.
Who did they sign that title over to?
Me.
Oh, you values mirror.
You want to go to Atlantis?
I think we might need to go there just for a drink. So the title, we can't take too much more time up on this, but the title was signed over to you.
Correct.
So you were the equitable owner at the time of the accident.
Correct.
And you have your own insurance company?
Correct.
And have you made a claim with them?
No.
Okay.
It's also State Farm.
I hear you. First of all, I would make a claim with your insurance company, who will clearly deal with you. And they will go to the quote-unquote other insurance company, which happens to be State Farm as well, and probably make the other insurance company, which is State Farm as well, pay the money they're going to pay you, because you're their insured. So I change my advice. This is what attorneys do when they get more information.
Sure.
I would contact your insurance company and make a claim.
Even though it's now 2 months later.
Yes, absolutely.
Okay, remember my name, because if this doesn't work, I'm coming to your office.
All right, Gene, you call my office.
You're going to have to go to Atlantis
which
for
is
me.
781-8003. You call my office if you need to, and we'll chat with you some more.
All right, have a great day.
Take care. You too. Bye-bye.
The Atlantis Hour here on WPS.
That was
what?
There was really a very interesting fact scenario. Look, this is really what does happen.
I must live in a cave.
We get calls every day, and my dedicated paralegal, Cheryl, is the first line of defense.
Yes.
And, she, depending upon the situation, might spend 5 minutes on the phone with a prospective client before she comes to me and, gives me some of the information. Or I've seen her spend a half hour on the phone. And inevitably, if it's more complicated, I'll say, well, what about this, and what about that, and what about this? And if it's only a few pieces of information I need, I'll have her call back the prospective client, which we call a PNC, potential new client or prospective new client. Try to get some more information, and she'll come back to me. And then we'll make a decision whether or not, to offer a consultation, whether there's a case there. Then there are those situations where it seems like I need to speak with the person before we even make that decision whether or not there's a case. And this would have been one of those probably. Because my understanding of the fact pattern led me to one set of recommendations. But further discussion led to additional information, which really changed the primary recommendation as to how to solve the problem. And that happens more often than anybody would believe, because the people who call us aren't lawyers. They know they have a problem. They may not even know the problem is called hostile work environment. They may not know the problem is called, I have a problem with the Family and Medical Leave Act. They know they have a problem. And they describe the problem to us, some of them much better than others. And you know, again, you're dealing with all different sorts of individuals. And, you know, it's really our job on our end to try to decipher the information we're getting and to figure out, are we getting enough information to try to determine whether there's a real case there, or to, you know, indicate to the person, well, we're just not able to handle it. You know, you might want to try another attorney. Different attorneys have different views on things. Because I will virtually never say to somebody, you don't have a case. If I tell somebody you don't have a case and I'm wrong, I may have committed legal malpractice. The most I'll usually do, there are exceptions to everything, but the most I will usually do is say, I really see a lot of problems here. I'm not sure that you have a case that, you know, could prevail. You know, other attorneys see things differently. You should at least contact one or two others, you know, before you make a decision not to proceed based upon a lawyer's advice. So, that is sort of the way it works. Now, so after
Getting back to your notes.
getting back to my notes,
My head is still swimming from that.
we haven't even done one page, which is wonderful. I love how fast an hour goes on radio.
We used to have a doctor on the air, Dr. Jason Schwartz, and God love him, this man prepared for his show 32 pages. 32. and he was
For an hour show?
wall-to-wall calls. And it was like, it
Yeah.
took him 6 months to get through all of his material.
Well, I like the calls. Hopefully,
yeah.
the information I provide when I'm talking, you know, is helpful to some people. And sometimes I will tell you it does lead to calls the next week in our office. So, you know, that's nice to know, even if there's silence here for the hour. But I appreciate the calls we have received, and it's still open to anybody else. In addition, on your general damages to the economic damages, you have non-economic damages, which essentially is pain and suffering, or damage to your reputation, emotional anguish. And there are two types. There is what the courts call garden variety, and then the courts don't really have a name for the other one. I'll just call it really bad.
So how do you prove emotional?
There's a lot of good ways. I had a client, it wasn't a defamation case, but I had a client whose employer held a gun on the staff, not intending to hurt them. It was stupid. Wanted to show a gun that the person had purchased.
Yeah.
Okay.
Yeah.
And this particular client had a gun incident in her past 20, 30 years earlier, and she went into PTSD. And she lived in her master bedroom closet for at least a week, afraid to come out, that he was going to show up at her house to kill her. She went into counseling. She was put on medication. 3 years later, when the case went to mediation, she was still in counseling. It was pretty easy to prove emotional anguish and you know, harm. Then I had another case, a defamation case, which I think I talked about on air, where the woman who was a high school guidance counselor was accused of, you know, having sex with kids and providing them alcohol. And she would say she would be walking through Publix and she would see somebody that she was friendly with at the other end of the aisle, and they'd turn around their cart and just leave. And it happened a lot more than once. Publix, Walmart, what have you. People that they used to go out with would no longer answer their calls. Another great way to prove emotional anguish, damage to reputation.
Yeah, I see.
So there are a lot of good ways to do it. And when you can't do it that way, then you're probably dealing with the garden variety. And what does that really mean? It means that it wasn't so serious to either lead you to a doctor, lead you to a therapist, lead you to medication. It bothered you, it upset you for some period of time. And so how much is that worth? It's a lot less than, when you live in your master bedroom closet for a week. But it has value. If you were defamed, you are, and especially if it's defamation per se, that damage is presumed. It has value. But the value it has is in the decision of the jury. So my job in that point is to tell the story well through opening statement, through witnesses, through closing argument, and to try to get the jury to look at what might be a run-of-the-mill, emotional anguish claim, and try to push the number up as high as I can. And that's my job as an attorney, and the other attorney is going to do the exact opposite. So, next week we'll talk about special damages, nominal damages, and punitive damages. So hopefully that's a good cliffhanger for next week, and we'll go into a little bit more of other stuff. We'll talk about a case where somebody was accused of boiling his wife in a vat of acid, and that was a defamation case I had.
Defamation.
It was an internet. Internet defamation. That's a brand new area of the law that's really big now.
Internet
Being defamed on even on stock message boards. Beware, folks. What you say can hurt you. Anyway, I think that is about time for this week. I'm Stuart Address. I hope you have a good weekend. My office is 781-8003 in Stuart. And next Friday, hey, give us a call. Ask a lawyer. Have a great weekend.
And opening a brand new second office on the island of Atlantis. Coming soon. This is WPSL Port St. Lucie. WPSL on Google Home, Alexa, and Echo.
And coming to you from the island of Atlantis.